Good afternoon, everyone, and welcome to the Senate Judiciary Committee meeting of Tuesday, February 20th. We're going to start the day by opening the public hearing on Senate Bill 591 and recognize the prime sponsor, Senator Bradley. Good afternoon, Senator.
Good afternoon, everyone. Thank you very much. And for the record, Jeb Bradley from Wolfboro, and pleased to be here as the sponsor of Senate Bill 591. I want to thank all the co-sponsors and apologize to several of you who there was just not enough time to ask 24 senators to co-sponsor this bill. So I just want to say that that's why there are not more co-sponsors on the bill. So it is what it is. So I just want to be clear about that. Those of us that were in the legislature in the past session would remember, I believe it was House Bill 1677 that was sponsored by my good friend from Conway, Karen Umberger. Made a really good faith effort to put behind us some of the really egregious behavior that happened in the past at the Youth Development Center. It created a settlement process that was victim-centric, designed to allow the victims to get financial compensation without having to go through the difficulties that I think we would all agree that they would have to go through in a trial. My understanding is that the last report to the Joint Fiscal Committee is some 77 cases have been resolved through the current settlement process at about an average of $450,000 per case. I think that Justice Broderick has done a really good job of making this initiative work. But I think going back to the debate that we had when this bill first was proposed, there were some things that some people felt would enhance the process and make it more likely that these victims, and there could be as many as 1,000 or more of them, would find more user-friendly. And that's where House Bill 591 comes in. I think it's always been the intent of everybody on all sides of this issue that a settlement process keeps the victims in particular, and we should be thinking as much about the victims as anything here, out of court. It allows for settlement for them. It protects the court system by not having runaway number of litigations, and it protects the state from a process that is very uncertain in terms of the financial implications. And that's why the settlement process is the right process. So as Justice Broderick and the Attorney General and the attorneys that represent the vast majority of the victims got into the process, there were some things that I think everybody felt would enhance the process. And that's where we're at today. I need to salute the Attorney General Fermella and his team. These were long and intense negotiations that didn't necessarily look like they were going to come to fruition, but everybody had an opportunity to get their point of view into this final piece of legislation and to try to come to a conclusion. I also think it's appropriate to give kudos to the attorneys, and you will hear from them today. the attorneys from Nixon Peabody and Riley and Associates, who represent the vast majority of the claimants. So having said that, let me try to walk through the high points of, and high points is probably not the right word, the important points of Senate Bill 591. So starting right off in the beginning, and I think that one thing that the Attorney General asked when we drafted this legislation is that it not be a repeal and replace, so that we could actually see where all the changes were being made. So it should make it easier to follow along. The first thing starts right on the first page on line 15, egregious sexual abuse. It's still it's at the discretion of the administrator, but with the language that defines what egregious sexual abuse is, it's in excess of the severity of the abuse experienced by most other claimants. And that is based on the nature, the frequency, the extent, and the severity of that abuse. And as we get further into the bill, you'll see that anyone that's qualified for the egregious sexual abuse will be entitled to a settlement of up to $2.5 million, not $1.5 million. I think that in the effort to try to resolve cases and some of the most egregious cases, that this is a good place for the state and for the victims and for the attorneys of the victims to be. I'm not going to go through every change. I'm just going to hit the important ones. On line 25, physical abuse becomes other abuse, and it is broader than just physical abuse. So it could be unlawful restraint or unlawful strip search, intentional affliction of emotional distress under New Hampshire law. So that broadens that category, and this was something that was very important to the attorneys representing the victims. On the top of page 2, talks about isolation and seclusion on lines 5 and 6. It further defines on lines 9 and 10 what unlawful restraint means. On line 19, unlawful strip search. So these are clarifying criteria for the administrator to be able to determine the level of claims. So moving on to page 3, and again, just trying to hit the important points. On line 12 through 14, new language is added that is the determination of the administrator, but accepted by the claimant, subject to the limitations. All of these appropriations would have to be approved by the fiscal committee, but it also broadens the authority of the administrators to render any final decision. Moving on to page 4, 2/3 of the way down the page on line 25 through 27, talks about duration, severity, the nature, the character of the abuse. And again, on line 28, talks about multiple abuses, okay, that's simultaneous. So again, further definition of this very difficult situation that these victims experienced in the past. Page 5, this is where the 1.5 million for egregious sexual abuse is increased, potentially, still at the discretion, obviously, of the administrator and the approval of the Attorney General. potentially up to $2.5 million. And then, if you recall, the second change in abuse, going from physical abuse to other abuse, is raised from $150,000 to $250,000. And also, as we earlier discussed, the isolated confinement of $300 a day, capped at no more than $100,000. This does broaden the scope of both the cost, but also the potential victims. But I think it enables the state to be able to settle without having to go to court a greater percentage of the cases in front of us. Next big change is on page 6. The claims had to be accepted under the current law by December 31st of this year. It's extended by 6 months. I think that given, the conversations I've had with Justice Broderick, who I think, as I said, is doing a commendable job, and a new change here, extending this by the 6 months is a reasonable compromise. Okay. I'm going to let the Attorney General and others speak about when a claim is settled and how the changes interact that, but basically the victims do not lose their rights until they have fully accepted the claims. So then, starting on page 7, much of the existing statute is repealed, but starting on page 9, it comes back. And again, I think appropriate to let the Attorney General and the attorneys walk through those changes if there are questions. Something that was very important to me on page 10 as part of the process issues, halfway down the page on line 16 and further below, is the victim-centric process, that we all want to make sure that the victims and their privacy and the difficult situation the victims are in, that the process is conducted in a trauma-informed, respectful, and dignified manner. I think that's very important for all of us. Again, on page 11, on how settlement claims between the Attorney General and the administrator proceed. And then I think the next really big item is on page 13, where the administrator can go before joint fiscal and ask for an additional $75 million in claims to be paid out in any given fiscal year. That is a large sum of money. There's no question about that. But I think for all of us, we know that how many potential claims there are. Resolving them in this fashion is a much better way for the victims and for the state and for the attorneys that represent the victims to go through the settlement process and the court process. New language is very important on line 20, that the administrator has the discretion within available appropriations to determine whether a claim shall be paid as a lump sum or periodic payments or something akin to an annuity. This is vitally important to protect our budget process, that these settlements be potentially paid out over time. The way that the attorneys propose to make that work, and I think it's a credit to them, is on line 26, that the victims would be able to receive 5% interest, which quite frankly, in this day and age is right in the middle of where interest rates, we probably want them to be at a much lower level than 5%, but they're at about 7% right now. So 5% is a compromise, and I think it's reasonable. At the bottom of page 13, payments have to be authorized, and the governor can draw a warrant. But again, the legislature still has appropriate say through the fiscal committee. Page 14 outlines how in the future some of these claims get funded. The administrator can go to the fiscal committee, the legislature can make appropriations, or there's the possibility that the state treasurer, with the approval of the fiscal committee, can issue a bond. And then the last major component of Senate Bill 591 is the cap on attorney's fees at 33.33%, which I think is reasonable, given all of the other compromises that have been made, a reasonable compromise. So, as I indicated in the beginning of my testimony, this was a long and contentious negotiations that the Attorney General and his team went through with the attorneys from Nixon Peabody and Riley Associates. I've passed out a letter that was addressed to me a couple of weeks ago. Riley Associates and Nixon Peabody represent, in the letter they say perhaps as many as 1,400 survivors and 1,100 complaints. What I think is really important in this letter is the commitment, if this legislation passes as introduced, and of course it's possible to amend it, but any amendments have to be agreed to by the Attorney General and the claimants, and the attorneys for the claimants, because this is a settlement, and compromises and suggestions need to go through that process. So I would ask the committee to respect that. But I think the key sentence in this letter is that the bill at the very end represents enough of an improvement that we anticipate recommending the improved process to the vast majority of our clients, as appropriate based on the facts and circumstances of each case. So again, settlement process has worked so far. This is an improvement, and I think we have a commitment, a public commitment from the attorneys representing the vast majority of the victims that the settlement process as outlined in Senate Bill 591 is workable for the vast majority of their victims. And I think in order to protect the victims, in order to protect the court system from just being inundated with claims, and in order to protect the long-term financial health of the state by being able to spread out the payments and manage this. Very unfortunate part of the landscape in New Hampshire today. This is what people would call a reasonable compromise, difficult as it may be, and it's very difficult. But as a state, we need to listen to the victims and respond appropriately and try to close this chapter in New Hampshire's history. So thank you, Madam Chair.
Thank you, Senator, for your testimony. Are there any questions from the committee? Senator Whitley?
Thank you, Madam Chair. Excuse me, and thank you for taking my question. It's really more of just wanting to amplify, why this is so important. I know that a lot of folks have been at the table, and I appreciate that work. We're talking about thousands of children who were subjected to horrific treatment when they were in state care. And this is something that should all keep us up at night until it's resolved, because it's horrific and it really should never have happened, and it should never happen again. So I thank you for that work, and I thank everyone involved for the work. I just want to continue to make sure that we are putting those victims at the forefront and every effort possible to make sure this never happens again.
And I would respond in this way. First of all, thank you very much. And no one in this room has worked harder for children's issues than you have. And again, I apologize that we didn't have enough time to get everybody to be able to co-sponsor the bill, but you deserve a shout out.
Okay, are there any further questions or comments? Okay, seeing none, thank you very much, Senator.
Okay.
The chair will call Attorney General John Formella.
Thank you, Madam Chair, members of the committee. Good afternoon. So we're back today to discuss Senate Bill 591, which is the continuation of our work to address, a series of horrific events that took place over decades at the former Youth Development Center. I want to start by just responding to something Senator Whitley said, which is that this should keep us up at night until it's resolved. And I can tell you, as Attorney General, whoever takes on the role of Attorney General, there are many things that keep you up at night, but I don't think anything has kept me up at night more than this issue. And as I've discussed before, when I've appeared before the legislature, there are multiple components to this issue. There's trying to develop a victim-centered and trauma-informed settlement process. There's the civil litigation that we continue to be engaged in. And of course, there's the criminal investigation and the criminal trials. So when it comes to what happened at YDC over the years, there are multiple components, and I can tell you it keeps me up at night. I'm sure it keeps members of my team up at night. On that note, before I get into some of the background of the bill, I do want to take a moment to acknowledge the difficult topic that this is, and how emotional and complex it is. And I've said it before multiple times, and I'll say it again. Both I and my team at the Department of Justice really extend our admiration to the victims who have had the courage to come forward and share their stories and talk about what happened to them. That's not easy to do, and it certainly isn't easy to do when we're talking about things that happened to people when they were children and that happened many, many years ago. So we admire the victims for coming forward. We applaud them for coming forward, and we understand that there may be victims who have yet to come forward, who may come forward in the future, and who may never come forward. That's ultimately up to each and individual victim, depending on their circumstances. As we continue to work on this process to improve it, we continue to hope that at least for some of the victims, and hopefully now the vast majority of victims, that this can be an avenue for much needed relief and healing and an appropriate alternative to going through litigation. The second point I just want to make before I get into some of the meat of my remarks is that I just remind the committee, I think everyone here is familiar with this at this point, but I remind the committee that on this issue, I of course play a dual role. I serve as both the chief legal officer for the state, and in that role, I'm charged with dealing with litigation brought against the state and dealing with things like this, a claims and settlement process like this. I also oversee the criminal investigation and the prosecution of the criminal cases. And so there could be questions that you might have that I might be, constrained in answering, but I'll of course attempt to answer any questions I can and get you any follow-up information that you might need as you consider the bill. Looking back to 2022, Senator Bradley mentioned we first began a legislative effort to address this issue in 2022. At that time, we had around 450 victims who had come forward and about as many lawsuits that had been filed. The lawsuits and the stories told by the victims discuss sexual assaults, physical assaults, solitary confinement, threats, many other terrible things that happened to a lot of these victims over the years. We said at that time that while many had come forward, we did not know the scope of what happened at YDC, and we probably would not know for some time. And I think that has proven true in an unfortunate way, but it has proven true. Today, the number of victims who have come forward is well over 1,000. It's probably all total closer to 1,500 than 1,000. There have been more than 1,100 lawsuits filed in Superior Court. So that's over 1,100 today compared to what had been 450 2 years ago. We recognize, and as we've recognized for the past couple of years, that traditional litigation can be particularly difficult for anyone, frankly, but it's particularly difficult for someone who's been a victim of sexual abuse, and especially for someone who's been a victim of sexual abuse as a child. And that's why we have endeavored to create this claims process that would provide an alternative to traditional litigation. In response to that, as you know, the legislature passed HB 1677 back in 2022 and appropriated $100 million to the claims fund that was set up under that bill. I continue to believe that the legislature did the right thing then, and I continue to believe that the state, as much as we should be ashamed of what happened at YDC, that we should be proud that we're making these efforts to make it right. I've said a number of times that this is a situation that developed over decades, and the reality is that a horrific situation that develops and evolves over decades is probably not going to be solved in a short period of time. Our goal is to solve it and resolve it and address it as quickly as possible, but it's going to take time, and this process has taken time. Under the process as exists today, I actually have some updated numbers from what Senator Bradley gave you, but he had given you numbers as of the end of 2023. As of today, the process has resolved 102 claims, and the average amount per resolution has ticked up a bit. It's now at around $492,000. 307 claims have been filed. So while we're here today to talk about improving the process, I do want to acknowledge the efforts of Administrator Broderick, and I do need to thank my team, and especially Jen Ramsey, who's been the AG designee in the claims process, for the work to get the claims that have been resolved. I, of course, also want to acknowledge those attorneys who have represented the victims in the process. I think just about every firm that's been involved in the process has at least one claim that's been resolved. So I want to thank everyone involved for moving that process forward as much as it could be moved forward. That said, as we've discussed this over the last couple of years, there have been three primary issues raised by claimants' counsel that have resulted in many victims not choosing to use the process. And those issues really are that the caps were too low, the scope was too narrow, and the process was too complicated. So while the bill in front of you makes a number of changes, I think it's best summarized by saying that it really aims to address those primary obstacles that many victims have raised to coming into the process: the caps, the scope, and the process itself. The longer we had to work with the current process, the more ability we had to really get a sense of how this type of process, which, as I mentioned, is incredibly difficult, incredibly complex, we had more chance to see how this really works in practice. It's one thing to lay it out on paper and to talk about it, but now that we've had a bit over a year, we've really seen how it works in practice. So last fall, with the benefit of some months working on this, we reopened negotiations with Nixon Peabody and Russ Riley from Riley and Associates. And we didn't know whether we would get to agreement, but we wanted to make a good faith effort to engage in discussions to see if we could make changes to the process that would make it an acceptable process for the vast majority of victims. We know, and we've always known, that we'll probably never design a process that's going to work for everybody. I don't think it's realistic to expect we could design a process that works for everybody. every victim has their own story, every victim has their own circumstances, and every victim has to be given the right to make their own choices. And I don't think we can ever expect that a situation that has created over 1,000 victims that one resolution can be appropriate for every single victim. But I am, I guess I don't want to say happy, because there's nothing happy about what we're talking about, but I am appreciative, I'll say that we have been able to get to a place where I think we have agreement on a product that's in front of you that will be able to resolve the vast majority of claims, and that will be appropriate for the vast majority of victims. We engaged in extensive discussions with Nixon Peabody and Russ Riley. They represent the vast majority of victims. And we had, I would say, difficult but productive discussions. We had at times contentious discussions, but discussions that were always respectful. And I think they were discussions that were entered into in good faith and with the best of intentions. And that has resulted in the bill you see in front of you. So I'm going to hit a couple high points on the bill. I don't want to be duplicative of what Senator Bradley went through, because he covered a lot of it, and I can certainly answer questions, but I want to mention the high points, a couple of them that he already mentioned. But first, the caps. So like I said, we've heard that for many victims, the caps are too low. At the end of the day, the caps are a compromise. There's no amount of money, I think, that can truly compensate for the type of harm we've heard occurred at YDC. It's part of an imperfect system at the end of the day, that our method for compensating for that type of harm is money, because there really is no amount of money that I think you could say is the right amount. But we have reached agreement on cases involving egregious sexual abuse to raise that cap from $1.5 million to $2.5 million, as Senator Bradley mentioned. The statute defines what egregious means, but at the end of the day, it really will be at the discretion of the administrator to determine whether a case involves egregious sexual abuse, and to determine how far above 1.5 million to go, up to a cap of 2.5 million. Each of these cases is different, and each involves different facts and circumstances. And so at the end of the day, while I think we can make a good faith effort to establish criteria for what qualifies as egregious, at the end of the day, you really have to leave it to the discretion of a decision maker and a neutral decision maker. So that is left to the discretion of the administrator. We've also expanded the scope of what's included in sexual abuse. So sexual abuse will now include indecent exposure, invasion of privacy. That was something we talked about back in 2022. And based on what we've seen and heard about what's occurred at the YDC, I think, cases of indecent exposure and invasion of privacy, perhaps if a staff member is inappropriately watching kids in the shower or recording kids in the shower, and maybe even distributing videos or pictures from that, in many circumstances, it's appropriate to consider that sexual abuse. At this point, I do note that, as you probably remember, after the legislation passed in 2022, we had to go through another process in front of the Fiscal Committee to write guidelines to really build out exactly what these terms mean and what qualifies under these terms and what each incident is valued at. We're going to have to do that again. So some of the details that you might have questions about really won't be addressed in the bill. They'll be addressed again when we go in front of the Fiscal Committee. For instance, indecent exposure, invasion of privacy, we're going to have that discussion regarding guidelines in front of the Fiscal Committee to determine what those will be valued at on a per incident basis. But the bill provides that they're now encompassed in the definition of sexual abuse. When it comes to physical abuse, we have changed that term to other abuse and expanded the scope of what's included in that. The scope has been expanded to now include reckless conduct, criminal threatening, child endangerment, unlawful strip searches, intentional infliction of emotional distress, and unlawful restraint and solitary confinement. The total cap for other abuse is increased from $150,000 to $250,000. A big topic of discussion back in 22 was whether to include solitary confinement in this. And the more we've seen of these cases, the more instances of solitary confinement we've seen. We've discussed with plaintiffs' counsel research that shows the damage that solitary confinement can cause. And we ultimately felt that it was an appropriate compromise to include solitary confinement claims in this process, but to cap those claims at $100,000. So those claims are $300 a day and capped at $100,000. Based on the information we have, we don't think many claims will come close to the $100,000 cap. And I don't want to put words in the mouths of victims for sure, and I don't want to put words in the mouths of their attorneys, but I do think a part of the reason to include these is to include this category of harm is to recognize it, and to recognize that it happened, and to recognize that it did have an impact. Again, no amount of money, or it's difficult to ever determine an amount of money that's appropriate for any category of harm, but it is important to recognize that harm occurred and that it has value. So that will now be included in the scope of other abuse. Senator Bradley mentioned this, but I think it really bears talking about again, and that is that as part of increasing the caps and thus increasing the amount of money the state will pay out under this process, we have reached agreement on the administrator's ability to award claims in annual payouts as opposed to lump sums. I think we would all agree that if we had the money and if we could do it, we would pay every victim what they were due in a lump sum. But I think that the reality of the state's finances are that if we're going to commit to paying out a larger sum of money, and now that we know we're dealing with a number of victims that numbers above 1,000, in order for the state to manage this process, most claims are going to have to be paid in some form of yearly payments. And so this bill provides for that. In the prior version of the legislation, the administrator could not mandate yearly payments. The administrator will now be able to do that. And the administrator will have the obligation and the authority to manage the fund so that no more than $75 million is paid out of the fund in any fiscal year. That said, the administrator will have the ability to go to the fiscal committee and the governor and council to get that cap increased if it's appropriate and if it's necessary and if the state has available funds. But we felt there needed to be at least some certainty in here for budget purposes, and that's how we addressed it. As Senator Bradley mentioned, the yearly payouts will have 5%, will be subject to 5% interest. So that was our way of trying to be fair to victims, understanding that victims may end up needing to take payments in yearly payouts because of the state's budget reality, but they should be compensated for that in a fair manner. And the 5% is essentially a compromise between the current rate of 7% and the lower rates that we've seen in past years of 2 to 3%. 5% is a compromise between those two amounts. The last thing that the bill does, it addresses the third problem that I mentioned, which is that the process was too cumbersome, it was too complex, it took too long. There's an element of this that is just reality when it comes to a process like this. As I mentioned, we all recognize, and I think we have now learned, to the extent we didn't realize it before, that a horrific situation that developed over decades is not going to and really cannot be resolved in a very short period of time. But our goal is to resolve it as quickly as possible. So the process changes involve shortening some deadlines to speed up the process, giving the administrator the ability to waive those deadlines in certain situations so that we speed up the process as much as possible, but recognize that flexibility is necessary. And frankly, sometimes a victim and their attorney will need more time to navigate the process. So it gives the administrator flexibility, but also speeds up some deadlines. It also creates more flexibility in settlement negotiations. In the previous version of the legislation, the Attorney General's designee had to indicate the AG's position on a claim within 30 days. That initial indication of a position is now optional. The Attorney General's designee has the option to indicate an initial position within 21 days. but we can also wait and continue to negotiate all the way up to a resolution proceeding. And we also have the option of waiting until a resolution proceeding even happens to indicate a position. The benefit of this is that it creates more flexibility in negotiations, but the other benefit is that it can be very difficult to form an accurate position as to an appropriate number for a claim before someone's had a chance to speak with the claimant or the victim. And we recognize that many victims are not going to want to talk directly to us. They're going to elect to speak with the administrator or the administrator's team. But one of the process changes that's made in this bill is that we can hear that conversation. We don't necessarily ask questions in it, but we have a chance to listen to that conversation, be present before we form a position on a claim. And I think that's a change that is going to be really helpful for us in formulating fair and appropriate positions on claims. It's a very, very difficult reality, but the reality is that many victims will not want to talk to us, but we have a really hard time assessing a victim's story without hearing their story. And reducing a victim's story to paper is very difficult. And there's no perfect way to address these types of issues, but that's what we've tried to do in the process changes that you see in this bill. As Senator Bradley mentioned, this also extends the deadline to file claims to June 30th of 2025. And I think that is, there had been some discussion about potentially extending the deadline longer, but I think 6 months is a reasonable compromise, and it is necessary given that we're making some significant changes to the process. And those changes won't really be final until we go in front of fiscal in the summer and early fall. So extending this deadline to June 30th, 2025, I think is an appropriate compromise. Before I close, I want to, like I said, this is not an occasion to celebrate or to express happiness over, but it does bear, I think I should express appreciation first to my team, so to Associate AG Matt Broadhead and Senior Assistant AG Sam Garland. They're here today. They really gave me a lot of assistance in negotiating these changes with Nixon Peabody and Russ Riley. I want to thank Jen Ramsey, who has been the AG designee during the claims process and has really engaged in some difficult work and work that often draws a lot of criticism. But that's the nature of the work we do. It's difficult work, and so it draws criticism, but we're prepared for that, and we accept it. But I want to thank her for her work. I want to thank Nixon Peabody, specifically Mark Knights, who's here today, and Dan Dean, who worked very closely with Matt Broadhead and Sam Garland in these negotiations. I do want to express my appreciation to Dave Vicinanzo and Russ Riley for their willingness to engage in these discussions. And again, I want to, while they may not have been at the table for negotiations, I of course want to again extend my admiration to victims who have been willing to come forward and tell their stories and through their counsel engage in these discussions. This is very difficult. This is a very difficult topic. And as difficult as it is for us, it's far more difficult for the victims who went through the experiences they went through and who now are coming forward to tell their stories. But Senator Whitley said it, and I think it is something we all need to keep in mind, and we certainly do, that at the end of the day, this is about them. It's about the victims. It's not about us. It's our job to do what we can to seek justice for the victims, and justice has many components. One of them is trying to provide a fair process by which a victim can receive fair compensation. Another component is to make institutional changes that guarantee that this doesn't happen again. And I think the state is doing that. And another is to seek justice through the criminal justice system, which we are doing. And those are difficult criminal cases, but they need to be brought. And they need to be given the best effort possible. And then finally, in the cases where we do have to litigate, while we may have to litigate, we try to do it in as respectful of a manner as possible while fulfilling our obligations to defend the state. I think everybody who's been involved in that has played their own part in trying to bring justice to the victims. So I think that just bears keeping in mind. And so I want to thank the members of the committee for listening. I'm happy to take questions. And we have a lot of work to do still and a long way to go in these efforts. But I think this bill represents another significant step in the right direction.
Thank you very much for your testimony here today, Mr. Attorney General. Are there any questions? Senator Gannon and then Senator Whitley.
Two probably easy questions for you. How much funding have we put aside now total?
The total amount put into the fund has still been $100 million. About $52 million at this point has been committed through resolutions.
Okay. And so just say, like, if it was the high end, everyone got $2.5 million. With 1,000 people, not counting future claims we could have, it could be a huge number, like $2.5 billion if everyone got the 2.5 times 1,000. So what are you anticipating that the average award will be?
So far, the average award has been about $492,000. To get to your question on the $2.5 million, out of the 102 claims that have been resolved, 9 have been resolved at the cap. And so that gives you a sense of the percentage of claims that are resolved at the cap. I would certainly expect the average to go up from 492,000, but it's difficult to pinpoint exactly what the average will be until we get all of the claims that are going to be filed. I can tell you that when we were in front of the Senate 2 years ago and in front of fiscal that year going through the guidelines process, we actually pinpointed an appropriate average per claim number at about $720,000. So we're currently well under that average. And so that's the best estimate I can give you, but it's going to be difficult to give you an estimate until all the claims are filed.
Quick follow-up?
Yeah.
Follow-up.
So if we went with your 492, we'll round it up to 500 to make it easier. At 1,000, we'd be looking at 500 million, not including any new claims.
We
So
could
we're
be.
short money. It just seems if it was 500,000 a case times the 1,000 you said, that's $500 million without any new claims.
Yes, I mean, this,
We sound like we're short money.
yeah, the bill, I mean, yeah, we certainly are going to need more than $100 million to address all of the claims. Part of the way we've tried to address that reality, as I mentioned before, is having most of these claims paid out over years. So that even if the total were something like $500 million, it's not going to all be paid out in 1 or 2 years.
Yep. Okay, thank you.
Yep.
Senator Whitley.
Thank you, Madam Chair, and thank you for going further into the process. Again, what is most important to me is recentering on, who we're actually talking about here. And we're talking about children, and children who were subjected to abuse in state custody. And many of these children who are now adults, not all of them are adults, this is not as far back as I think we all would like to think it was, but many of these victims are, of course, suffering the impacts, not only from what happened to them at the facility, but also the fact that they went into the facility with a certain amount of trauma. The children who were at this facility, that are at this facility, are our most vulnerable children. These are our children that need the most help. And so I am curious, I know a lot of lawyers were involved in this, and I appreciate why that was important. And I'm curious, who was involved to make sure this was a victim-centered and trauma-informed process? Were there victim advocacy organizations, victims themselves? Who was at the table to make sure this isn't going to be a re-traumatizing process?
Yeah, it's a good question, Senator, and I appreciate it. And again, I reiterate, my agreement with your sentiments, of course, that we have to remember who we're talking about and about the trauma that they've experienced. In the latest negotiation, so I should say, in the latest negotiations over what the statute looks like, we didn't engage from our end, we didn't engage in depth with our Office of Victim Witness Assistance or with the professionals that the administrator has retained to help the process be victim-centered and trauma-informed. But we absolutely are going to engage with all of those folks when we go to change the guidelines before the fiscal committee and as the process plays out in real time. And why is that? Yeah, I'm sure you're asking why is that? Because the words in the statute just lay out some really general parameters. The administrator and his team have done a really good job retaining experts and consultants to help them make the process victim-centered and trauma-informed. And we've had a lot of discussions with them on that front. They have done a lot of work to make the resolution proceedings where the victim themselves is involved, victim-centered and trauma-informed. And the details of how the process works really are found in the claims process and the claims guidelines, not in the statute itself. So I think the victims have certainly been represented both by their counsel in drafting this legislation and, of course, by us, given that we ultimately have an obligation to represent the public and victims of crime in anything we do. But I think it is most important to engage victims and professionals who have experience serving victims in the claims process and guidelines, and then as we actually carry out these proceedings. I think the legislation is pretty high level and broad and really just sets out broad parameters.
Thank you. Are there any further questions? Senator Gannon?
Just help me, I just like math. It seems like we only have enough to give right now, 100,000 per person, if you have 1,000 people. It seems like we're gonna be way short money
Yeah,
to go to the victims.
yes. I mean, $100 million is going to be, if the average stays where it is and we get over 1,000 claims, yes, we will be short.
Okay, thank you.
Okay, are there any further questions? Okay, seeing none, thank you very much. The chair will call Mark Knights.
Good afternoon, Madam Chair, members of the committee. My name is Mark Knights. I'm a partner at the law firm of Nixon Peabody. I, together with my partners David Vicinanzo, Dan Dean, and our co-counsel Russ Riley, as you heard, represent a substantial number of the victims who resided at the YDC and the state's other youth facilities. I think at this point, we're actually over 1,200 filed cases in Superior Court. I've been working on these cases now for several years, and it's been a very humbling experience working with the victims. I've heard folks in their 30s, 40s, 50s, 60s tell me some of the worst things that can happen to a person. And I am sometimes the very first person that they've ever told those things to. And based on that experience and the experiences we've had, all of us on the plaintiff's team, we've always believed that some sort of a settlement fund would be the most appropriate way for those folks to resolve their claims against the state. Only a fraction of our clients, as you know, have chosen to enter the settlement fund as it's currently constructed. And those folks who have entered the settlement fund have not always settled their cases against the state. They've settled claims based on incidents of abuse, but they have not settled their complete cases because the settlement fund did not cover things like solitary confinement, like emotional abuse, and other things that are now covered in this bill. To its credit, the Attorney General's office recognized some of these problems with the bill and came to us several months ago. And we engaged in, as you heard, extensive and sometimes contentious negotiations. They were not easy. There were times when we thought that those negotiations would not move forward. And I have to give some credit as well to Administrator Broderick, for bringing us back to the table at one point when we thought we would not be able to reach a compromise. But ultimately, we were able to reach a compromise, and that compromise is reflected in the bill before the committee today. Like any compromise, there were things that we wanted that we didn't get, things that we gave up. And does that mean that we are not happy with the result, that we are dissatisfied in some way? It does not. We are satisfied with the result. We believe that with the changes reflected in the bill, the vast majority of our clients, as you've heard, will choose to enter the fund. When they enter the fund, the changes to the bill will result in cases being settled, not just claims being settled. It will result in alleviating some of the burden on the Superior Court that these cases pose, and we are certainly very cognizant of that. And those changes, most importantly to us, will help our clients, the victims, receive complete relief for their experiences while they were in state custody. I'm not going to repeat or belabor any of the points that were made in our letter or repeat the changes and the benefits we see from the changes, which you've already heard about from Senator Bradley and from Attorney General Formella. I do have a statement from one of our clients who supports the bill. He is a client who has submitted a claim to the settlement fund already, but he is in support of the changes to it. This gentleman, his name is Brett Malcolm. He's a former first responder, a former firefighter. He filed his claim as a John Doe, but he saw these changes as being so important that he is willing to forego his anonymity for these purposes. And I'm not going to read that full statement. You have it here before you. But Mr. Malcolm, when he was around 16 years old, was sent to the Toby School, which was a special education school for kids with educational and behavioral disabilities. And while he was there, he was raped multiple times. He was beaten multiple times by staff members. He describes the settlement fund process that he has gone through as a nightmare. He says, the Attorney General designee told me I shouldn't be able to settle my case because I was never involved in the juvenile justice system. I can't understand how that makes sense. Because I was a kid with emotional challenges instead of a kid who committed a crime, what happened to me doesn't matter. Hearing that was incredibly frustrating. It made me feel like the state didn't care about what happened to me, which is exactly how I felt when I was a kid being beaten and raped. The settlement fund experience made me feel like a victim again. He goes on to say, I'm thankful that my attorneys at Nixon Peabody and Riley and Associates are fighting to improve this process for us. The deal they negotiated with the Attorney General's office would ensure that, going forward, the settlement fund can serve its intended purpose, to provide all kids who suffered in state care with a measure of justice and vindication for our trauma. And he closes by saying, I appreciate that the state is trying to do the right thing by changing the settlement fund to make it inclusive and victim-friendly. I wholeheartedly support these changes, and I hope you'll decide to pass the bill. Not all of our clients are as articulate as Mr. Malcolm, but that is a sentiment that I have heard from many of our clients who I've spoken to about the changes that we've negotiated to the settlement fund. And like them, we at Nixon Peabody and our co-counsel at Riley and Associates do wholeheartedly support the changes. I'm happy to take any questions that the committee may have.
Thank you very much for your testimony, Mr. Knights. Are there any questions from the committee? Senator Chantley.
Thank you very much, Madam Chair. I'm wondering if you could possibly outline a little bit about how the changes made in this legislation do make it better for the victims and better for your clients.
Sure. Well, as you heard from Attorney General Formella, the process as it currently stands requires us to submit a claim packet on paper that describes the victim's experience. And it's very difficult to get an idea of exactly what happened to the person and capture that all on paper. And so the amount of information that the Attorney General's office has to take a position in the case is necessarily limited by that medium. the way that the process is set up in the changed bill would not require the Attorney General's office to take a position, which sometimes, based on that limited information, can be much lower than the Attorney General's office would otherwise come out if they had the opportunity to hear from the victims themselves. Under the change process, before the Attorney General's office has to take any sort of a position, they can hear from the victims first. And so the victims don't have that hurdle that they have to get over of submitting a claim, laying out all this traumatic, all these traumatic memories on paper, only to get a number that they feel doesn't really do justice to their lived experiences. The changes in the process remedy that particular issue.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you.
The chair will call Michaela Oliveira. Good afternoon.
Good afternoon. My name is Michaela Oliveira. I am a claimants attorney with Manning, Zimmerman, and Oliveira in Manchester, and also a board member of the New Hampshire Association of Justice. And I'm here today in support of this bill. I wanted to speak with you today a little bit about the claimants that we represent, and who they are and how this process has been for them. I've had the opportunity to represent several claimants before the fund. I currently represent claimants before the fund, and I have claimants I will represent in front of the fund. These claimants are from all walks of life, of all ages. They are men, women, 30s, 40s, 50s, 60s. They are people who have spent time at one of the YDSU facilities, but have gone on to become successful business owners, or have gone on to continue to be entangled in the criminal justice system due to the variety of trauma they've suffered, not just through their personal lives, but also through the abuse that they've suffered at YDSU facilities. But the one thing that I've had with claimants who've gone through this process, who have now settled their claims, the one thing that they have in common is that the validation and acknowledgement of the state, that the state recognizes this abuse that they suffered, and is trying to make that right, has been exceptionally validating. That doesn't mean my clients want to talk with anyone from the state. They are generally incredibly mistrustful of anyone from the state, not just the Attorney General's office, but the Administrator's office. Sometimes we are, like Attorney Knight said, we're the first people that they're telling of their abuse. They've kept it to themselves for 40 or 50 years, and it's incredibly embarrassing for them to talk about their most deepest trauma in front of strangers. So we've been lucky that we've been able to work with the Attorney General's office to come up with ways in which our clients can tell their story, but in a way that is victim-centered, and hopefully as minimally traumatic to them as possible. Because just by talking about their story, that can be re-traumatizing. But making sure that our claimants have the mental health support that they need in order to get through the process. And then ultimately, if they do settle their claim, using these funds to make sure that they're getting the mental health and medical care that they may need going forward as a result of their abuse. I have clients who are using the funds that they've received from the YDC Settlement Fund to create college funds for their grandchildren. I have claimants who are buying their first home so that they can have a stable place to get medical care and a stable place that they can call their own, because they've never had that before. So I just wanted to come today and speak about the actual people who are being helped by this claim, and how this claims process, while it does have its kinks and we've been trying to work around them, that there are success stories coming out of it. One of the provisions I wanted to highlight is the provision that hasn't been talked about yet, but it gives the administrator the opportunity to shuffle hearings based on the illness of the claimant. I had a claimant who was diagnosed with a terminal illness while their claim was pending, and that was an issue of first impression because this is a new process, and we all had to work together to figure out how we could get their testimony before they passed due to that terminal illness. So I'm here today in support of this bill and would urge that the committee adopt it. Thank you.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Tony Scullenberg, kind of scribbled there at the end, so.
Good afternoon, Madam Chair. My name is Anthony Scullenbrady. I am here on behalf of NHAJ, and I want to express support for the bill. I have 2 points I want to make, and I want to respond to something Senator Gannon asked the previous witness. So the first point is this. Changing the statute in the way that is proposed would help get more people into the process. It would help victims get their recovery sooner. It would give taxpayers some degree of cost certainty, which with pending litigation, they may not have. So I think that the changes are good in the sense that they are going to bring more people and hopefully most of the people into the process. I want to point out that while certain things have been added to claims, the things that have been added are added with inconsistency with existing New Hampshire state law. So for example, the emotional distress claims. As a plaintiff's lawyer, I can tell you that emotional distress claims are probably the second or third most frequent call that we get. And invariably, or almost always, we have to tell them that New Hampshire is a state that has really high standards to prove intentional infliction or negligent infliction of emotional distress claims. Adding that to the claim process will not greatly expand the number of people that can make claims. Generally speaking, because the standard of proof is so high, there has to either be some extraordinary event or it's part and parcel with physical abuse that already exists. So I don't think that any of the additions in terms of what new claims that have been added will greatly increase the state's liability, while at the same time they will offer a chance to make victims more whole. The second thing that I wanted to point out, and this is a small change, has to do with the language for strip searches. And if the committee wants to look, I believe it's on it's on the bottom of page 1 and the top of page 2. So subsection 1I talks about other abuse, and it includes the language unlawful strip searches. In order to clarify a couple of factual scenarios that I can talk about in a second, I would suggest that the language should be amended by moving it from paragraph I to paragraph J. And in doing so, it would be consistent with not only common sense, but it would also be consistent with other kinds of cases. For example, there was a Supreme Court case written by our own Justice Souter in Stafford Unified School District versus Reading, where they talked about strip searching kids in school. And while these kids were not in school, they were the same age. And there the Supreme Court found that those kind of searches are inherently bad. And I would contend that an unlawful strip search is inherently sexual. The next thing I would point out is that in subsection J, some of the statutes that are referenced require proof of an act for purpose of sexual gratification. And it is possible to conceive of a scenario in which you have an unlawful strip search that does not happen for reasons of to satisfy sexual gratification. And so by making it clear that all unlawful strip searches constitute sexual abuse, it will clear up a bunch of different scenarios. The final thing I would point out is that by moving the language of unlawful strip searches from I to J, it would mean that we wouldn't deal with silly edge cases. So for example, the current setup has it such that if there are emissions that end up in somebody's mouth, it could constitute a sexual assault versus a physical assault. In the case of strip searches, oftentimes the people were humiliated in a way that resulted in bodily fluids being put on them. If the bodily fluid, one drop, happened to land in the person's mouth, then it becomes treated, it gets treated differently. Whereas in the current scenario with the bill as proposed, if it's happening in an unlawful strip search, it could just be deemed other abuse. So we wouldn't want small differences in facts for similarly situated people to result in radically different recoveries for really just happenstance or accident. So I would ask the committee, if they were to consider passing the bill, to amend the language just to move that one three-word phrase, an I, to subsection J, to make clear that any unlawful strip search is sexual abuse. The final thing I would point out is that while we have an idea in our head of what a strip search counts as or what constitutes a strip search, having worked in criminal cases for years, I can tell you that strip searches are vastly more invasive than people realize. It's not just seeing somebody without clothes on. It's a very probing analysis. And I think that it's hard to conceive of a reason to do an unlawful strip search that doesn't in some way constitute sexual abuse. If it's an unlawful strip search, it should be viewed as inherently sexual abuse. And so we'd ask for those two changes, or that one change. Senator Gannon, you asked about cap cases and you asked questions about finances to the Attorney General. The Attorney General gave you like good average. One thing I can tell from the cases that have come to me is that cap cases are exceptionally rare. When you expand the cap the way that the bill proposes, it not only is factually rare, but because the increased standard to show exceptional abuse, it's just not going to be met very often. The vast majority, I would imagine, although I don't have the same data as the Attorney General, the vast majority of cases are going to involve some kind of physical abuse. And very, very few, in the anecdotal data that I've seen, people asking me, people calling my office, very few have been cap cases. So while it is obviously the concern of the legislature to figure out where all the money is going, I just can't see that everybody's going to come in and hit the cap. It's almost impossible to imagine a factual scenario where that happens.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Ms. Chase, I know it looks like maybe, I'm not sure because you've checked out both yes and no.
I meant to cross out my yes, but I do want to clarify something that Attorney Scullenbrini said. My name is Marissa Chase. I'm the Executive Director for the New Hampshire Association for Justice. Our members represent victims before the fund. And I just wanted to say, I wanted to thank the Attorney General's Office for a constructive dialogue ahead of today's hearing and their assurances that it is not the intent of this bill to devalue a traumatic occurrence of sexual assault, which happens during a strip search, any less than sexual assault in any other context. We appreciate all the work that's gone into this legislation and look forward to continuing to engage in the process.
Okay, thank you very much. Are there any questions from Ms. Chase? Seeing none, thank you. Okay, seeing that everyone who wished to speak has signed up and spoken, are there any other members of the public that would like to speak to Senate Bill 591? Okay, seeing none, we'll close the public hearing. The committee will be in recess until 3. the committee will come out of recess. Is there a motion to go into executive session?
Yeah.
Moved by Senator Chandler, seconded by Senator Gannon. Okay, everyone should have a list that was sent out about the bills we're going to try to exec today. We have a hard stop at 4. So let's see what we can accomplish today. What we do not accomplish today will get added to the list for Thursday, and Matthew will be sending you out that list when we get back upstairs.
And I probably have a hard stop like 3:45, I would say on
Today?
Thursday.
On
No,
Thursday? Okay.
Because I have to get to the airport.
Okay, we know that. Okay, first one we're gonna take up is Senate Bill 313.
I have a motion for it to pass.
Okay, seconded by Senator Abbas. Is there any discussion on 313? I think it's pretty self-explanatory, came from the commissioner. Until I actually heard the testimony, I thought minimus had something to do with a farm. Okay, we have a motion about to pass, and it's been seconded. Are there any further comments? Okay, seeing none, the motion is ought to pass. All in favor say aye. Aye. Any opposed? Okay.
Move consent?
Senator Whitley moves consent. Is there a second by Senator Chandler? Okay, is there any further discussion on the consent calendar motion? Nope, seeing none. All in favor say aye. Aye. Any opposed? Who would like to take this one out? Okay. Okay. Okay, next we have Senate Bill 316.
Move on to pass.
Senator Abbas moves ought to pass, seconded by Senator Gannon. Is there discussion on Senate Bill 316? Senator Whitley.
Yeah, I think, we had a lot of good conversation about a number of these bills related to penalty, and I think we're all in agreement that we want to address the opioid crisis. I think, there is no disagreement about that, but I think how we do it really matters. And I think anything that we're doing in this space really has to be backed by evidence. And unfortunately, there is zero evidence that the mandatory minimum bills actually work to, achieve the stated goal of the sponsor. And in fact, it could have some harmful effects. We know that these mandatory minimums are often applied in racially disparate ways. And also, we're taking the decision out of judges. I think, judicial discretion in these types of cases are really important. And I think, a draconian mandatory minimum just doesn't make sense when we're actually, it's not going to be the deterrent that one is hoping. I can understand why we would hope it would be a deterrent, but there's just no evidence that it is. So it's not a solution that I can support.
Thank you. Are there any further comments? Senator Gannon, then Senator Abbas.
Yeah, Officer Bright on all these fentanyl-related bills, we'll just call them that. He felt that they were in crimes where you had time to think about what you're going to do, that he thought that there was a deterrence effect. And so I'm listening to the guy out in the street, and where he said, if they can think about it, not crimes of passion, but a crime that you think about, and they're going to want to stay with their family, and they're not going to do these if they know they're going to get hard time. Thank you.
Senator Abbas.
Pretty straightforward. Fentanyl is killing people. People are dying of overdoses. It's not being manufactured in the state. It's being brought into the state and distributed. And I don't think that has anything to do with people's races, their religions, their background, nothing. People know they're bringing a drug in here that's killing people, and there's a consequence of that. And one way to deal with this, I understand there's a mental health component, there's rehabilitation, but also stopping the fentanyl from coming into the state illegally with the intent to distribute is a major way to do that. And this is a step in the right direction. So this is sending a message to the people who are going to import drugs into the state that are killing people. If they do so, they're going to face a stiff penalty, and they need to be aware of that.
Okay, Senator Whitley.
Yeah, and look, again, we all want to solve the crisis. And I asked, once we heard, on the one hand, we heard pretty clearly that there isn't any evidence that mandatory minimums work. And, I asked the state police officer who came, like, if you truly think this is going to be a deterrent, I would love to see the evidence supporting that. And he just wasn't able to provide it, and he never did. So, and I think the other issue is that what we're talking about here are people in the throes of addiction. I don't see how a mandatory minimum is going to be a deterrent for someone in the throes of addiction. Like, why not focus on actual evidence-based interventions? This is a very draconian step. And I think at the same time too, there's no, well, I'll just there.
Okay, are there any further comments or questions? Okay, seeing none, the prevailing motion is ought to pass. All in favor say aye. Aye. Any opposed?
No.
Okay, Senator Abbas, would you like to take this one out?
Yes.
Next, we have Senate Bill 327. I would like to move on to pass.
Second.
Seconded, okay. Is there any discussion on this? Senator Chandler?
Thank you, Madam Chair. I will support this. I think it's, and I will declare that I have a husband who has been an official. I have, even my kids have been officials. I've participated in sports, youth sports, college sports, and high school sports as a spectator because my family are all involved. And I've seen some of the terrible behavior exhibited by participants in the sports. However, most of it doesn't rise to the level of criminal. This bill addresses the behavior that's rises to the level of criminal by adding this new penalty. I am hopeful that the penalty will dissuade people from acting criminally, but I think that it is only the penalty. I'm not sure. I'm hoping that the organizations that govern these sports will take more responsibility for making sure that folks who are participating in the sports in any capacity demonstrate good behavior.
Senator Abbas?
Just to clarify, I agree that I think the penalty in this case will act as a deterrent. So I agree with my friend's comments. I think it's very important to protect sports and people being targeted like that. The penalty will act as a deterrent. So I agree.
Okay, are there any further comments or questions? Okay, seeing none, the motion is ought to pass. All in favor say aye.
Aye.
Any opposed? Okay.
Move consent.
Senator Whitley moves consent. Is there a second? Seconded by Senator Chandler. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Senator Chandler, would you like to take this one out? Okay. Okay, next we have Senate Bill 356. Okay, motion for interim study and has been seconded. Okay, is there any discussion on the interim study motion?
This is 356.
Yes, this is 356. Okay, all right, seeing no discussion on the interim study motion, all in favor say aye.
Aye.
Any opposed? Okay, there's a motion for consent.
So moved.
Moved by Senator Whitley, seconded by Senator Chandler. Is there any discussion on the interim study, the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Okay, any opposed?
Slow on you. Sorry. We'll get better, Madam Chair.
Okay, Senator Gannon, would you like to do this one? Okay. Okay, Senate Bill 359, we are going to hold.
And my apologies for not
Nope,
getting that
that's
amended
okay.
sooner.
Next, we have Senate Bill 362. We do have an amendment. I'd like to move ought to pass, seconded by Senator Gannon. The amendment is number 0781S. And I'll speak to the amendment. We still have the LEAC Commission that's up and working. And so I thought that this would be, rather than create another legislative study committee, these are law enforcement officers that are actually doing this work. They are in contact with other law enforcement agencies around the country. There are accrediting associations that they might be able to, if we ask them to please give us a report identifying issues raised with the copying, distribution, or use of body-worn camera images, including but not limited to disclosing sources and methods of investigations, privacy of suspects, law enforcement officers and civilians, and constitutional obligations. And then submit that report to us, and then we'll have an idea about where we need to go. Senator Whitley,
Just
and then Senator Gannon.
Is this different? Is this still the commission that was formed by the governor?
Yes,
Because they haven't met for 3 years.
we meet regularly.
I
Oh, okay.
there's
Yeah, we
there's
meet.
two commissions that
This is
sound
what
very
I-
much
I
like.
didn't know. Okay.
This is statutory.
I see. Okay.
Yeah.
So this is the different one.
Yes, this
I
is a different one. I sit on it as well as a member from the House. And one of the things we just finished was the standardization model.
Got it.
Because we found out that police departments do everything differently.
Yeah.
So, so that is that commission, they do meet every month.
Okay. I'll second your amendment.
Okay, so we have a motion of ought to pass on amendment number 0781S. Is there any further discussion on that proposed amendment? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, so we have a motion on the bill of ought to pass as amended. Is there a second? Second by Senator Gannon. Is there any further discussion on the ought to pass as amended motion? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for the consent calendar? Moved by Senator Whitley, second by Senator Chandler. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
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 Any opposed? Okay, and I will take this one out, Matthew. Okay, next, we have Senate Bill 414. Senator Gannon moves out to pass, seconded by Senator Abbas. Is there any discussion on the ought to pass
Sure.
motion? Okay,
So
Senator Gannon.
continuing, I see things as justice as a four-legged stool, and I do appreciate the senator from Concord when she's talking rehabilitation. Without it, we're gonna turn people back on the streets. But I think there's also three other roles. One, incapacitation to take the person off the street who's committing these crimes. Retribution for the family members who have lost a loved one, and there's a deterrence. And so I think all four work together, and if you don't have any one, the chair's probably gonna fall over. So that would be my reasoning.
Okay, is there any further discussion? Senator Chandler.
Thank you, Madam Chair. I can't support this bill for similar reasons to the other one that we heard. Mandatory minimums, I think are extremely problematic. We have not seen them to make a difference in whether or not people are committing crimes. Now, there are other factors, much as Senator Gannon, you said, I agree with you. There are other factors that we take into consideration when imposing sentences. But I think that making the sentence mandatory takes discretion away from the courts, and that is problematic and not terribly helpful to resolving the problems as I see it.
Senator Abbas.
Thank you, Madam Chair. I support the bill. Listen, these drugs that people are overdosing on and dying of, people who distribute them know what the possibility of that distribution is, especially when you're dealing with a synthetic drug or drugs that have been laced and cut into other drugs. They know when they give this to someone that they could very easily overdose on it and die. And they're doing it anyway. So I think this is one tool in putting that out there, that if you do that and you're doing something that you know could very easily cause the death of someone, especially considering what you're doing is a crime in the first place, I think this is a good policy going forward, and it's just one tool for us to combat the opioid crisis that we're facing in the state.
Senator Whitley.
Yeah, so I think this is another case where we agree on the problem, we just don't agree on the solution. And what we heard that, again, I think we should legislate based on actual evidence rather than anecdotes. And what we know is that studies are showing that the people that are facing these death resulting charges are not dealers. They are companions. They are folks that are in desperate straits themselves. So we're targeting the wrong group. So, I think we agree on the problem. This is not going to solve the problem. And again, we're taking away judicial discretion. We're creating strict liability, which, doesn't seem to be effective at all. It's not something I can support.
Right, we have an ought to pass motion on Senate Bill 414. Are there any further comments? Okay, seeing none, all in favor say aye. Aye. Opposed?
No.
Okay, Senator Gammon,
Yep.
would you like to do this one? Okay, next we have Senate Bill 415.
Motion for ought to pass.
Okay, we have an ought to pass. Is there a second?
Second.
Second by Senator Abbott. Is there any discussion on Senate Bill 415?
Yep.
Senator Whitley?
Yep, again, we heard that same arguments. We just know that mandatory minimums don't work. There are so many solutions that we can be working on. Again, I asked the state police officer, is there evidence to support this works? Wasn't able to provide that. I just think we should be legislating based on evidence, and we just don't have it that it works. So because we don't have an evidence-based solution here, it's not something I can support.
Are there other further comments? Okay.
Yeah, I would.
Senator Gannon?
Officer Bright, I thought was very clear on his 25 years in the street, that he saw that if they knew what they were facing, he thought strict sentencing would be a deterrent.
Okay. Senator Abbott.
Thank you, Madam Chair. And I understand on paper, people look at this law and they think it's only apply to people doing hand-to-hand interactions at the street level. And when that happens, or if it's two people that are addicts that are together and they're interchanging stuff, it's really hard to prove who's point A and who's point B in those cases. The problem is the people that are dealing this stuff in high quantities and spreading it out throughout the streets of the state. And they're bringing it in here, they're spreading out through our communities, and it's causing people to die. It's a tremendous drain on our justice system. It's a drain on all of our resources, top to bottom. Whether it's the law enforcement continuing to have to deal with this, the paramedics, the medical side of it, and it all starts here with people who are buying this stuff and using it and then redistribute it amongst the population. People who go to rehab, they get out of rehab, and what happens? They go right back into that environment because the person selling it is they're in the business of sales. And that's what they do. That's what's happening at the street level. And we're going to put out there, this is a strict penalties is one tool of addressing this. And if people want to avoid these penalties, very easy. Don't sell drugs. Don't sell the opioids in the state. We're not going to stand for it.
Okay, thank you. All right, we have a pending motion of ought to pass. Is there any further discussion? Okay, seeing none, all in favor say aye. Aye. Any opposed?
No.
Okay. Senator Abbott, would you like to take this one out, even though it's Senator Gannon's bill? Is that okay? Okay. Okay, we are going to hold Senate Bill 418. We're still kind of working on that one.
Okay.
Next, we have Senate Bill 419. Is there a motion?
Ought to pass.
Okay, we have a motion of ought to pass. We also have amendment number 0122S. And Senator Gannon, would you like to speak to your amendment?
We really stripped the thing down. It's just a reporting statute of cannabis use for the therapeutic program.
Okay. Senator Chandler?
Thank you, Madam Chair. May I ask a question of Senator Gannon?
Sure.
I believe, if I'm remembering correctly, that we heard that the way that the reporting was described in this bill was unusual.
So
Can I?
there
No, no.
is, I'm sorry, go ahead.
No, and I just wanted to ask your reasoning for keeping that.
I'm gonna have a floor amendment. I
Oh,
just hadn't got to it. To add to it, I just hadn't got to it.
Yes,
Perhaps
please.
we can do that now because I think the concern was it was unusual to include statement of findings and corrective action plans. So if the sponsor's okay of the
I'm
amendment.
fine with it, and I know what you want to do, I just don't have it ready.
We're not gonna hear that, it's not gonna be on the floor for a couple of weeks. So you'll have plenty of opportunity to come up with a floor amendment.
Wants certain language, and I'm fine with it, it just didn't get to it.
Yeah, I think we can do it in right now, a committee amendment, because it's just removing the reference to corrective action plans and,
Okay, I'm fine with it.
okay. So, I would propose
Well, I have concerns about why wouldn't you want to have correction action plans? Because we do that when we do audits of departments. We give them a list of the deficiencies and, we want to see what corrective actions need to be taken. So why should this department be any different than any other one? I don't understand that. I think that, what Senator Gannon had proposed in his amendment, that you're looking at the number of inspections, the number of complaints, the number of investigation of the complaints, a statement of findings, an alternative treatment plan, a treatment center plans of correction, and, those that are not in compliance with the provisions, of the RSA or administrative rules, why wouldn't we want any of those to be included? I think that if you're going to have these types of programs, I think it's important that you do know what is going on with these things. I mean, I think of Maine, where through their distribution center, I remember being told, I think in a hearing, that there were problems where their marijuana that they were selling was loaded with pesticides and mold. I think for the health and safety of our constituents, that if we're going to be doing this, that we should be getting these types of reports. So I don't have an issue with any of the reporting. I think the more reporting you do, the better off you are. So that way we're ensuring that people, that are folks that are getting the medicinal marijuana, that it's being grown properly and processed properly, and they're not in violation of the law. So I don't have an issue. Senator Gannon? I'm sorry, Senator Abbott. Sorry.
Oh, it's no problem. Madam Chair, thank you. I agree with you. And in the interest of time, I'm not gonna, it's like going into some of the administrative rules that apply to some of the therapeutic facilities, because I think that may take a long time.
Mhm.
But and I know, being on the commission that met this fall, there was some concerns with some of the rules, although maybe well-intended, the enforceability of those rules, how they're being applied. So I look at this audit as very serious, because I will say from what I saw on that commission, the ATCs appear to be doing more than required of them.
Mhm.
With that being said, many of the rules in place, I weren't comfortable with their, one, enforceability, two, the efforts to actually enforce those rules. So I really would be curious, and I'm interested to see what findings are made by this. So I think, as it is, I would like to keep the amendment as it is, proposed by Senator Gannon.
Okay, so we are talking about Amendment 0122S. Senator Chambliss.
Thank you, Madam Chair. I appreciate Senator Gannon's amendment, and I do think the reporting is important. I think, as Mr. Holt said, and we've all seen, the reporting is generally very good. My question to Senator Gannon to start is just, I'm trying to figure out if there is a way to find some language that might be a little bit, that may be a little less, I guess the word is prescriptive, and allow for a little bit more consistency with other departments. So, I really, this is not something I would necessarily oppose, but I would love to work with Senator Gannon moving forward to come up with a floor amendment that might be a little bit more palatable to the department. I don't know if that's something Senator Gannon would be open to doing.
No, I'm fine.
Okay. Okay, so we have amendment, ought to pass motion on amendment 0122S. Is there any further discussion? Oh, second, I thought, okay. Okay, so we have amendment 0122S. Are there any further questions, concerns about the amendment? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay. We have an ought to pass as amended motion on Senate Bill 419. Is there a second? Senator Gannon. Is there any further discussion on the ought to pass as amendment? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay. Is there a motion for consent?
Can I ask that we not put it on consent, just in the possibility that I may have a floor amendment?
Sure, that's fine. Right, Senator Gannon, would you like to take this one? Okay. Okay. Next, we have Senate Bill 420. Is there a motion?
I move on to pass.
Okay, Senator Whitley moves ought to pass on Senate Bill 420, seconded by Senator Gannon. Okay, is there any discussion on the ought to pass motion?
Yeah, I would like to submit amendment 0447, which creates an end date for the committee as suggested by my chairwoman.
Yes. Okay. So you're also repealing the repeal.
Repealing the repeal.
We're repealing the repeal.
Thank you.
Okay. So is there any further discussion on amendment? We need a motion on the amendment.
I move the amendment.
Okay. Okay, moved and seconded.
Is it 0447?
Yes, 0447S. Okay. Is there any discussion on 0447S? Okay. Seeing none, all in favor say aye. Aye. Any opposed?
I move
Okay.
to pass as amended.
Okay, we have a motion of ought to pass as amended. Okay, is there any further discussion on the ought to pass as amended? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, Senator Whitley. Oh, is there a motion consent? Is there a second? Seconded by Senator Chanley. Is there a discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, Senator Whitley, would you like to?
Yes.
Okay.
Madam Chair.
Yes.
I don't know if this would be appropriate, but I was thinking that on the bill, which I asked not to go on consent, if I said, could we reconsider consent, it may be more sensible for me to pull it from consent if I do have an amendment. That way we don't have it we don't have to deal with it on the calendar. So if we reconsider the
Okay.
vote on the consent.
Okay, so we have a motion to reconsider our vote on Senate Bill 419 for consent calendar.
No, we didn't vote on the consent.
Yeah, I don't think,
We don't
I think,
need to-
I think it was withdrawn.
Okay,
Yeah.
so, all
No,
right.
she didn't make a motion on, no one made a
Right.
motion.
So if I might, I will move consent on
Okay,
our recommendation on SB
419.
419.
I'll second that consent.
So we have a motion and a second to consent, the consent calendar for Senate Bill 419. Okay, is there any further discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, so that was consent. Okay, next we have Senate Bill 425. Okay, Senator Gannon moves ought to pass. Is there a second? I will second. Okay, is there any discussion on Senate Bill 425? Okay, seeing none, All in favor say aye.
Aye.
Any noes? Okay. Is there a motion for consent
So
calendar? Moved by Senator Whitley,
Second.
seconded by Senator Challery. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Senator Gannon, this is yours. Would you like to take this one out too? Okay. We are going to hold 426 because we're still trying to figure that one out.
Okay.
Next, we have Senate Bill 460. We have amendment number 0776S. I'll move up to pass on the amendment. Second by Senator Gannon. I'm going to turn this one over to Rick.
So there were two issues with this bill. The first one, in the first section of the bill as introduced, proposed to make any violation of FAA regulations a criminal offense in the state of New Hampshire. I spoke to Attorney Tom Velarde at the Attorney General's office, and he confirmed that that was potentially problematic in a couple of different ways. First of all, nobody really knows what those regulations are, the way they're required to with general criminal laws. And I also have a concern about you all exercising your police power in a way that simply refers to decisions somebody else has made in a faraway place and not defining the crimes yourself. So that part's been removed. The other change is to basically downgrade across the board the criminal penalties associated with each of the offenses. For instance, in Roman 2, Section A has to do with negligence operation of a drone that interferes with or disrupts the flight of aircraft. That was originally a felony as introduced, and I wasn't able to find any statutes in the criminal code that make negligent conduct a felony other than negligent homicide. And obviously the consequences of negligent homicide are very different than disrupting an airport. And that would apply, by the way, to very small airports as well. And across, throughout the amount of penalties were just downgraded one notch, but the elements of all the criminal offenses remain the same.
Okay, so we have a motion of ought to pass on amendment 0776. Is there any further discussion? Okay. Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Next, we have, I'll move ought to pass as amended on Senate Bill 460. Is there a second? Okay, seconded by Senator Gannon. Is there any further discussion on Senate Bill 460 as amended? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for the consent calendar? Moved by Senator Whitley, seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye. Any opposed? Okay, and I'll take this one. Okay, next we have Senate Bill 502. I move ought to pass on Senate Bill 502. Seconded by Senator Gannon. Is there any discussion on Senate Bill 502? I think this bill is pretty self-explanatory. We're starting to see across the country people that are scamming people out of their property, pretending to be them. And if we give our real estate agents the ability to scan a driver's license, proving that you are who you say you are, hopefully that this is going to stop this practice. So we have a motion of ought to pass. Is there any further discussion? Okay. Seeing none, all in favor say aye. Any opposed? Okay, is there a motion for consent?
So moved.
Moved by Senator Whitley, seconded by Senator Chandler. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Any opposed? Okay, and I will do this one also, Matthew. Okay, next we have Senate Bill 504. Okay, Senator Gannon moves ought to pass. Is there a second by Senator Abbas? We have amendment number 0314S that was given to us during the hearing. Is there a motion on the amendment? I'll move on to pass on the amendment. Is there a second? Second by Senator Gannon. This amendment replaces the bill, and it seems to have satisfied everyone who was against the bill. So there seems to be a consensus concerning this subject amongst all the interested parties, and I think it's a good step forward. So is there any further discussion on amendment number 0314S? Senator Whitley?
Yeah, this is a replace all, so I just want to sort of back up on what we're doing and why. The bill sponsor said it was, necessary because of the issues on the northern border. And I think it's become pretty clear in the past several weeks that we really don't have a problem on the northern border. We heard from the Canadian consul who came to the general court and said the northern border is working. We got data recently that saying that there was only 21 apprehensions over 15 months. It's just not a problem. I think that this bill is in search of a solution for a problem that doesn't exist. I think this bill would make significant changes to our 50-year-old current use law. And it would do so by creating this really new untested immigration enforcement tool. So I think we need to be very careful here, because I think the unintended consequences is that it would clear the way for, suspected undocumented migrants to be potentially arrested by local law enforcement instead of federal border patrol agents for criminal trespassing. And I think, that could be really problematic, because what's the difference between someone, what's to distinguish, a potential migrant carrying a backpack from any other hiker? And I think there, it could be some racial profiling incidents. So I think there's not a problem here. And with the unintended consequences, even with this amendment, the folks from Space said, we won't even do what the bill sponsor wants, even with this amendment. So I don't think this is necessary at all.
Thank you. Are there any further comments or questions? Senator Chanley, then Senator Abbas.
Thank you very much, Madam Chair. I just want to say that relative to land and current use, I am nervous about the bill, even as amended. And while the amendment does satisfy some of the concerns raised, one of the folks that we heard from, Mr. Levesque, from the statewide program of action to conserve our environment, did express a certain level of skepticism regarding whether the amendment would resolve any concerns and whether the bill was necessary. And for that reason, I will not support this bill.
Okay, thank you. Senator Abbas?
Withdrawn.
Okay, so we have amendment number 0314S, which replaces the bill after the enacting clause. Is there any further discussion on the amendment? Okay, seeing none, all in favor say aye. Aye. Opposed?
No.
Okay, 3-2. Okay, we have an ought to pass motion on Senate Bill 504. Is there one as amended? Senator Abbas?
Passes amended.
Seconded by Senator Gannon. Is there any further discussion on the bill as amended? Okay, seeing none, all in favor of, say aye.
Aye.
Aye. Any opposed?
No.
Okay, so 3-2. Senator Abbas, would you like to take this one out?
Sure.
Okay. Next, we have Senate Bill 509. Okay, we have a motion for interim study. Is there a second?
Second.
Seconded by Senator Chandley. Is there any discussion? We already have this in statute. It's just that simple. So we have interim study motion. Is there any further discussion on the interim study motion? Seeing none, all in favor say aye. Aye. Any opposed? Okay, is there,
I move consent.
okay, Senator Whitley moves consent. Is there a second? Seconded by Senator Chandley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye. Aye. Any opposed? Okay, I will take this one out. Okay. Next, we have Senate Bill 563. Okay, Senator Gannon moves on to
Second.
pass, seconded by Senator Gannon. Is there any discussion on the ought to pass motion?
Yes.
Yes,
Senator Gannon, then Senator Whitley.
sure. Quick synopsis. We have no vetting going on at the non-existent border that we don't have, resulting in that we have people in our midst who, in the last year, we've had murderers, rapists, pedophiles, armed dealers, all within our towns or neighboring thereof. So seeing that the federal government hasn't made it safer, we want to make sure that states do not practice sanctuary city practices, or as they called it, welcoming ordinances in Lebanon and another couple towns. So all we're doing is not asking them to enforce federal law. We're just saying, don't get in the way of federal law. The good senator from Concord pointed out the expenses. I spoke to some of the state troopers about this, and they said, God, we just dropped them off at the Stafford County Correction. There's no cost to our localities. So I think the de minimis costs, other than if we don't have to even house them in our local jails, it's a very small burden to just cooperate with the federal government in the cases where they think someone is a danger. And so to me, it's a public safety bill. Thank you.
Senator Whitley?
Yeah, I think this is the rare case where we have a lot of folks who are very, very concerned with this. Municipal Association, ACLU, Catholic Diocese. We got a letter from a whole host of chiefs, including the Manchester Chief of Police. So I think, last week we had a whole conversation about gun safety in our state. We heard a number of times, our state is the safest, our state is the safest, our state is the safest. Well, here we have a bill that our law enforcement doesn't want. We have a bill that is inflaming,
Mike.
inflaming our community. We have our immigrant community really upset about this. This feels like, again, a solution in search of a problem that's really harmful to communities. Our law enforcement are saying we don't need this. This is absolutely a mandate. Best efforts is at best unclear. It's a federal mandate here. I don't know how we can read it any other way. It's a mandate for local police to do what federal immigration officials say. You can't really read it any other way. And so I feel like we're basically telling law enforcement that they have to do the bidding of the federal government. It's sort of inconsistent with other bills that we've recently passed. I think there's a harm to the community that we heard time and time again, folks coming to us saying, this is really harmful to our communities. This is not a problem. You're creating a problem that's really harmful, divisive, and unnecessary. So I really hope we do not pass this bill.
Okay, are there any further comments or questions? Senator Abbots?
Thank you, Madam Chair. Yeah, I think what gets lost in this debate is we keep talking about the immigrant community. If you're a lawful immigrant or lawful resident in this country, you have nothing to worry about. This focuses on illegal immigrants. People who are immigrating here illegally or not staying in this country legally. And I think for us, we don't want to be a sanctuary state per se. And I hear a lot of people want to say, oh, well, this is not being inclusive or it's inflammatory. I think we're asking people to follow our law when they come here. And I don't think there's anything wrong with that. A lot of countries throughout the world have immigration policies, but here in New Hampshire, what are we dealing with? And if we had a large influx of people come here, migrants come here, we already have a housing crisis. I don't even know how we would handle that. I've heard no solutions to that. But at the same time, on top of all of this, when there's public safety concerns that go along with that, what's the problem with wanting to enforce our laws and having immigration enforced? You've seen what's happened at the southern border. People keep trying to focus, the northern border is not a problem, not a problem, not a problem. People act like what's going on at the southern border doesn't affect us here in New Hampshire. It does. And it's an ongoing problem. And those numbers are rising at a staggering rate. But what we can do here in New Hampshire at the ground level is pass a bill like this that we're not going to allow for sanctuary cities, and we're certainly not going to obstruct with the few immigration laws that the federal government does want to enforce. Certainly don't think it's right for us to now obstruct the enforcement of those laws. It's bad enough they're not enforcing the border laws. So I'm going to support the ought to pass. Thank you, Madam Chair.
Good. Senator Chandler?
Yes, thank you very much, Madam Chair. I think that if we look back on the testimony that we heard and the people that we have heard from, it's clear to me that this is a solution in search of a problem, which is not to say that there isn't that there aren't problems that exist perhaps at the southern border, but within our state, we are asking our local law enforcement to do the work of the federal government with no additional resources, no additional training. And we are proposing this bill, the sponsor talked about how this bill was essential. It was essential to enhancing public safety. Yet, as was pointed out by Mr. Dunn from the Catholic Diocese, the people who are responsible for public safety are not asking for this. I cannot support it. I don't think it, again, I really don't think this bill does anything to improve our public safety, and in fact, may actually do us a disservice.
Okay. Senator Whitley?
Yeah, and I just want to reiterate or amplify that last point that, this is a purported public safety bill, but we got a letter from the chiefs from the following cities: Manchester, from Cheshire County, from Dover, from Portsmouth, from Nashua, from Merrimack, from Hudson, who said clearly to us that they're concerned about the impact of this legislation on the safety of our communities and with it weakening the relationships that they have with minority populations in communities of color. So I don't really know what we're trying to do here other than make a statement, a political statement, when our law enforcement is saying that this will undermine community safety.
Senator Abbas?
Thank you, Madam Chair. I appreciate the comments, but I keep saying it doesn't matter what your race is, your religion. It does not matter if you're here legally. If your status is legal, this will have no impact. What this has to do with illegal immigration, which not every illegal immigrant, by the way, is a person of color. If you are here, if you want to come to this country, we ask you, we come here the right way. And simply put, to say that this is causing, some type of disagreement or some type of conflict in minority populations, if the rhetoric is causing confusion, that's unfortunate. But if they're here legally and whether they're a United States citizen, whether they're here on a visa, they have nothing to worry about. This will have no impact on them. And I think it's important that we take a stand here in New Hampshire that we're going to support lawful immigration, and that's what we should do.
Senator Chandler?
Thank you. I just want to make one comment. Good senator has said that this will have no impact on people who are here legally. I am looking at the broader picture, and I do in fact think it has an impact on all of our communities, not just the immigrant community, but all of our communities. This legislation would have an impact, and from my perspective, that impact would be on balance quite negative.
Okay. Are there any further comments or questions? Senator Abbas?
Thank you, Madam Chair. I'll just pose the hypothetical. Should we then become a sanctuary state? I think that's the alternative. Do we just go the other direction?
Senator Whitley?
I think that we should actually focus on New Hampshire problems. And this is not a New Hampshire problem. A New Hampshire problem is hungry kids, housing crisis, opioid crisis. I want to solve New Hampshire problems. I don't want to, solve problems that are inflamed by national politics. That's what I want to do.
Okay.
But would you support New Hampshire becoming a sanctuary state? Maybe amending this and this letting New Hampshire have no immigration enforcement whatsoever. Is that
I think it's
direction? Is that yes or no?
Okay.
May I
Okay, I
respond?
think respond, and then we're going to end that going back and forth.
I think the so-called sanctuary state, sanctuary community is a political term. It doesn't exist. I think I want to be a welcoming state. I want people to follow the law, and I want our communities to be safe. This bill doesn't keep our communities safe. That's what I want.
Okay.
Thank you.
Senator Gannon?
No, but
Okay. Okay, so we have an ought to pass motion on Senate Bill 563. Are there any further comments? Okay, seeing none, all in favor say aye. Aye. Any opposed?
No.
No, I don't think you want it.
No.
Okay. Senator Gannon, do you want to take this one out? Okay.
Probably change your mind.
Okay, the last bill that we are going to do today is Senate Bill 565. Is there a motion on Senate Bill 565?
Oh,
Oh,
I didn't know that.
I'm sorry, I heard that too, but
I didn't know.
Okay, maybe we should hold, yeah, I haven't seen an amendment, but she said there is an amendment.
Okay, so
Just now?
we're not gonna,
Okay,
okay, so we're
Right.
not going to exec. So we.
hold on. Thank you, Kate.
Okay, we have gone through all the bills that we had scheduled to go through today. We've got, four that we did not do that have some additional things coming along. We also have the, hearing that we had today.
Yeah.
We will exec that one on Thursday as well. But,
Do we want to exec that today?
well, the attorneys were kind of hanging around and for 591, the one we heard today.
I told the lawyer from Nixon after speaking with you that you weren't going to exec on it today, and he left based on that.
Yeah, so we can do that on
Based on-
Thursday.
Based on the fact that I told him you weren't going to exec on it.
Yeah,
Okay,
so,
absolutely.
no, I think we just need maybe a little time to let it settle and, so can I get a motion to come out of executive session?
So moved.
Okay, seconded by Senator Gannon. All in favor say aye.
Aye.
Opposed? Hey, we are through for the day. Thank you all very much.
Senator Carson, somehow I thought I heard you had an amendment. It must have been someone.
No.